All right, let's jump right in. We're going way back to the very first year after India's brand new constitution was born. We're going to explore a legal battle that, believe me, would go on to shape the entire destiny of the nation for decades to come. So here's the explosive question that India was grappling with back in 1951, right as it was taking its first steps as a new republic. Can a government just change its own rulebook to get what it wants?
Now, to really get what this whole conflict was about, we've got to first understand the promise that was made.
So picture this. It's the early 1950s. India is fresh out of colonial rule. The new government is fired up, They're on this powerful mission for a massive socio-economic transformation, aiming to build a much more equal society for everyone.
And their number one goal? Taking down the old feudal zamindari system and giving land back to the people who actually worked it. Now you got to understand, this wasn't just some policy debate. This was about fulfilling a core promise of the entire freedom struggle. But there was a huge obstacle standing in the way.
And where was that obstacle? Well, ironically, it was right there, written into the pages of the very same constitution that was supposed to deliver justice and equality to all. This really lays out the central clash perfectly, doesn't it? On one side, you have the government's goal, land reform and social justice for the landless. And on the other side, a massive constitutional roadblock, the fundamental right to property. This right essentially protected the huge landholdings of the very landlords the government was trying to reform. So what happened next was almost predictable. The powerful landlords took these new reform laws to court, and the state high courts, they started striking them down one by one, calling them unconstitutional. I mean, this was a massive problem. The government's entire flagship reform agenda was literally being taken apart piece by the judiciary.
So, with their backs against the wall and the courts blocking their every move, Parliament decided to do something bold, something really controversial. They basically decided to create a super shield to protect their laws.
And this super shield came in the form of the first constitutional amendment, passed in 1951. It did something pretty radical. It introduced Article 31B and something called the Ninth Schedule. Think of the Ninth Schedule as a kind of constitutional lockbox. It was designed to protect certain laws from ever being challenged in court for violating fundamental rights.
The process was ingeniously simple. Step 1, Parliament passes a land reform law. Step 2, landlords, as expected, challenge it in court. But then, Step 3, Parliament just takes that law and places it inside the Ninth Schedule. And voila, Step 4, the law is now totally immune from any judicial review. It was a direct, powerful way to get around the courts. But of course, a move this big was never going to go unchallenged.
And that challenge came almost immediately. This radical new amendment set the stage for the very first major constitutional showdown in India's Supreme Court. The case that started it all was Shankari Prasad v. Union of India in 1951. And this wasn't just any case. It would set a precedent that would reverberate for decades, putting the immense power of Parliament head-to-head with the authority of the judiciary.
So the whole legal battle boiled down to this one crucial question. You see, Article 13 of the Constitution says that any law that takes away a fundamental right is totally void. But Article 368 gives Parliament the power to amend the Constitution. So the big question was, is a constitutional amendment made under Article 368 the same thing as a regular law under Article 13? If it is, then the First Amendment is invalid. If it's not, well, that changes everything.
So, all eyes were on the Supreme Court. They delivered a unanimous verdict, and their decision was incredibly clear and decisive. The court's logic went like this. There's a difference between ordinary law and constitutional law. When Parliament is amending the Constitution, it's using its constituent power. It's acting as a body that can shape the very foundation of the nation. That, the court said, is on a completely different level from just passing a regular law. And because of that distinction, Article 13, which applies to ordinary laws, just doesn't apply to constitutional amendments. So what was the bottom line from the Shankari Prasad case? A 5-judge bench decided that Parliament has the absolute, unrestrained power to amend any part of the Constitution. And yes, that includes the sacred fundamental rights. This was a total, complete victory for the government.
This ruling essentially established the idea of parliamentary sovereignty in India. Now, while it solved the government's immediate problem of getting land reforms passed, it kicked open the door to a whole bunch of much bigger, thornier questions about power, limits, and checks and balances. It really set the stage for a constitutional tug-of-war that would last for decades.
So it left everyone wondering, with this ruling, was Parliament's power now absolute? Was there anything it couldn't change? This verdict, as it turns out, was just the opening shot in a very long, very intense battle for the very soul of India's constitution. And believe me, that battle was far, far from over.